Thank you very much for attending this session. In the next 30 minutes, I will discuss the proposals for a new subsidy control regime here in the UK. I will start my presentation discussing the rules as they were before Brexit. I will discuss then what currently is applicable to the UK and especially its international obligation in this sector. And then I'll move to the UK consultation, the proposals in that consultation, and draw some conclusions. I'm the presenter, and my name is Paolo Palmigiano. I'm the head of competition, EU and trade practice in a law firm, Taylor Wessing. Let me start then with the situation before Brexit. Many of you will be familiar with the state aid rules in Europe. And those are based on one key principle, which is any aid granted by a member state or through state resources in any form whatsoever, which distorts or threatens to distort competition by favoring certain undertakings or the production of certain goods shall, insofar as it affects trade between member states, be incompatible with the common market. And those rules are obviously key in Europe, where you have a single market, so you want to ensure that companies do not receive large amounts of aid from government to ensure that they compete on equal terms. The key principle is that all state aid must be notified to the European Commission in Brussels, the Director General for Competition. And aid cannot be granted unless it's approved by the Commission. If the member states grants aid and then later that is declared illegal because, for example, it was not notified, then the company that receives it must pay back to the government. Not all state aid is subject to notification. There is a general block exemption regulation that excludes a large number of aid from notification. State aid was sort of a niche area for a long time, and then it became mainstream when we saw the financial crisis in 2008 and member states granting all form of financial aid to their banks to ensure that they were not collapsing. And the Commission rose to the challenge and created flexible rules that dealt with that situation. We thought that was once in a lifetime occurrence, but then we've seen again in the current pandemic, the Commission intervening and issuing guidance and exempting a large amount of aid to airlines, to activities in the tourist sector across Europe to ensure that companies can cope with the current situation. So what is the current framework in the UK? Obviously, we have left the EU, so the EU regime is no longer applicable, so therefore there is no longer the need to notify the European Commission. There are a few provisions which remain, which is if the Commission has initiated a case before the 31st December 2020, it is still competent to investigate. And if the UK government has granted some aid before the 31st December 2020, the Commission will be able to investigate that aid within 4 years from that date. So clearly, at the moment, we have no national regime. We've exited the EU. We're consulting on a new regime. What is applicable now? It's a sort of limbo. But there are certain obligations which still bite on the UK. And we have provision on state aid in the WTO, in the Trade and Cooperation Agreement with the EU, in the Protocol on Northern Ireland. But the situation is quite complicated. It's difficult to understand what public authorities should be doing. So what we've seen in our experience, we see public authority still continue to follow EU rules. Is the rules they're used to, is the rules they've been applying for a long time, and therefore they're comfortable that if they comply with those rules, it is unlikely that the aid will be deemed not properly granted. I mentioned the international obligations. What are those? And we'll start with obviously the most important, which is the Trade and Cooperation Agreement and the Protocol on Northern Ireland. In the TCA, it's interesting to note that the terminology changes. In the EU, we talk about state aid. In the UK, now it's subsidies. I think there's a willingness to move away from the same concept that have been used for a long time in EU law. But the TCA contains an obligation for the UK to have a subsidy regime, to have transparency in what is done, and create an independent body that will deal with state aid. Courts will have the power to order recovery, and there has to be, and it becomes part of the TCA if the aid, when it's granted, has a detrimental effect on trade or investment between the UK and EU. And that is still to be determined what that means. And if one of the parties believes the state has not been granted properly, then they can take unilateral remedial measure to react quickly. There are also some provisions in Article 10 of the Protocol on Northern Ireland. As you know, Northern Ireland remains for most of its activities into the single market. So obviously, EU state rules still apply if subsidies granted affect trade in goods between Northern Ireland and the EU, therefore between Northern Ireland and the Republic of Ireland. It's a catch-all phrase that actually captures subsidies which are granted in the Great Britain, which have an effect on trade between Northern Ireland and the EU. And both the Commission and the UK have issued documents to clarify what that means. But one can imagine a scenario where a company in the UK, which has a lot of subsidiaries in Northern Ireland, receive aid, and that company export to Northern Ireland, that clearly has an effect on trade in goods between Northern Ireland and the EU, so that aid would be captured. What that means is that the aid is still subject to notification to the European Commission, and it's illegal if granted without that. It might be legal if granted without notifying it to the Commission. The WTO, which has been mentioned several times in the last few years, deals with international trade. And there are provisions on subsidies. But first of all, subsidies in the WTO relate only to goods, not services, as it is for the state aid rules in the EU. And the WTO only prohibits two types of subsidy. Subsidies linked to export performance or the use of domestic over imported goods. All the other subsidies are deemed legal unless a member state of the WTO can show that they're causing harm. And if they do, then there is a dispute resolution mechanism, which clearly is quite burdensome, and it takes a long time, several years. Now that the UK has exited the EU, it's starting to enter into several free trade agreements, and they all seem to contain similar provision. For example, if you look at the agreement with Japan, there is a provision to give unlimited guarantee subsidies and rescue without restructuring subsidies. So let's move now to the UK consultation. It was launched in February and it's open till 31st of March 2021. There were 43 questions, and obviously the government is keen to explain why there has to be a new regime and what its purpose and its objectives are. The first and foremost is to facilitate intervention that deliver UK strategic interests, for example, in research and development and leveling up of regions. The consultation recognizes that it's not a question of going back to the state intervention of the 70s. It's actually to make sure that aid is used for delivering what are the objectives of the UK. The regime is also there to avoid a subsidy race between UK nations. You can imagine a scenario where the Scottish government, for example, were to give aid to a company on condition that it moves to Scotland. And you can see similar scenario where subsidies used in a way that has an impact on the UK, on the internal market in Great Britain. Another purpose of the regime is to respect international obligations. So in a way, bring into national legislation what are the international obligations that are discussed a few minutes ago. But also, ultimately, it's there to assist public authority to understand their obligation and how to give aid in going forward. So in a way, what you see is trying to do a lot of things at the same time, and certainly does some better than others. After the consultation, we expect now the primary legislation will be introduced, which will obviously create a new subsidy regime in the UK. So what are the proposals? Here in the summary is the key parts of the consultation. We'll start with what is a subsidy. We'll deal with the principles. We'll look at what are the exemptions from the regime, what are the prohibited subsidies, what are, if there are sector-specific provisions, the transparency obligation that we discussed earlier on, the independent body, and judicial enforcement. So the proposed definition of subsidy is not that dissimilar from state aid. A subsidy is a financial contribution provided by a public authority, such as a cash payment, a loan with interest below the market rate, a loan guarantee, which confers the recipient a benefit not available under commercial terms. It must obviously benefit a particular enterprise or a particular sector, and it must have harmful or distortive effect on trade or investment within the UK or internationally. It is clearly intended to be a light touch regime. So at the moment, there is the idea of creating compliance with high-level principles, which would then provide flexibility to authorities to grant aid. How the principle will be implemented will be given in following guidance. So the authorities will only have the obligation to follow and apply those principles unless there is an exemption. Now, clearly, it seems fine in principle, but lots of guidance will be needed so that it does not become a tick box exercise. And the consultation asks a couple of questions. For example, should any other principle be added, and what level of guidance would be helpful for public authorities? Due to the importance, I thought I would cover and mention the 7 principles. I will just read the principles because each of them is actually accompanied by an explanation of what it means. And you can read those in the slides on the right. So, principle number 1. Subsidies are provided to meet a specific public policy objective, to remedy an identified market failure, or to address an equity concern. Every concern obviously are social equity objectives that you might want to, for example, you might want to promote, for example, providing transport for residents of remote areas. Principle number 2, subsidies are proportionate and should be the minimum size necessary to achieve the stated public policy objective. Principle number 3, subsidies are designed to bring about a change in the practices of the subsidy beneficiary that would not be achieved in the absence of a subsidy, and that will assist it with achieving the stated public policy objective. Principle number 4, subsidies should not normally compensate for the cost the beneficiary would have funded in the absence of any subsidy. For example, it should not be used to cover everyday business expenses. Principle number 5, subsidies are an appropriate policy instrument to achieve the stated public policy objective, and that objective cannot be achieved through other less distortive means. Principle number 6, public authorities should seek to minimize any harmful or distortive effects on competition within the UK internal market that might arise from a subsidy. Principle number 6 is key to this government because, again, they're concerned about subsidies granted by the devolved nations. So actually, in relation to this principle, the government asked if in this scenario there should be a detailed competition review for high-risk, high-value subsidies in order to protect the internal market. And if it's a good idea to include it, then should it be included also to international trade? Finally, principle number 7, subsidies' positive contributions to achieving the objective outweigh any negative effects, in particular the negative effects on domestic competition and international trade or investment. So as you can see, it will be key going forward for authorities to comply with these principles, and a lot hopefully will be explained in guidance. It is planned that everything will be captured by the regime, but there will be some exemptions. The first relate to low-value awards, and at the moment it's considered to be less than £340,000. And the government is asking what measures should be introduced so these small awards can proceed quite fast with maximum certainty and minimum bureaucracy. So, for example, they're thinking about should there be a presumption of legality. Another type of subsidies that will be exempt from the regime is obviously relief to compensate for drought, flood, storms, or wildfire, or compensating business for the immediate economic impact of a pandemic, as we are now. But also subsidy to respond to national global economic emergencies, as it was during the financial crisis. And finally, subsidies aimed at services of public economic interest of less than £790,000 over a 3-year period. There will also be some subsidies that will be prohibited. And obviously, the first is the ones which are contained in the WTO, which obviously subsidies subject to export performance and subsidies which promote the use of domestic over imported goods. But also subsidies in the form of unlimited state guarantees when there is no limit on the amount of debt or liabilities covered, or there's no limit in the duration. And these are subsidies which are prohibited in the free trade agreements. But also subsidy to ailing or insolvent enterprises where there is no credible restructuring plan to restore the business to long-term profitability. In the EU, we have something similar where there is a test for undertaking in difficulty to which aid cannot be granted. It'll be interesting to see if ailing or insolvent enterprises will mean the same thing, something different. So watch this space. Some subsidy can be granted, but it will be subject to condition. For example, restructuring subsidies for financial institutions to ensure financial stability. There has to be a credible plan for restructuring. Subsidy to air carriers when there are certain routes of public interest that maybe the airlines would not cover, and subsidies granted to large cross-border international projects if they demonstrate there are social benefits. The government also considering whether there should be specific provision for certain type of subsidies, for example, subsidies to energy and environmental projects, subsidies for the development of disadvantaged areas, and subsidy to airports or for road infrastructure projects or to ports. If you remember what I mentioned, the Trade and Cooperation Agreement includes a requirement for the UK to be transparent in the granting of aid. So a transparency database will be created where authorities will be able to upload all subsidy schemes and individual awards above a certain amount. And again, one point that is included in the TCA is the creation of the independent body. And here there are lots of questions. Who should have that role? One authority or more than one authority? But most importantly, what is that role? If we start from the premise that this is a light touch regime, it's obvious that the independent body will not have the role to vet and clear or approve subsidies. So the government thinks about certain type of roles that it might have. For example, explaining with guidance the framework to public and private bodies, review periodically the effectiveness of the system as a whole, providing advice rather than clearance before the award is given for high-risk subsidies, review certain awards, for example, if there's been a complaint, empower to enforce certain element of the regime, such as in relation to improperly given subsidies, penalties, amend or withdraw the subsidies. So while it is true that this is trying to be a light touch regime, I think it is important that whoever will be the independent body will have the expertise and the experience to deal with aid. And so one possibility, which obviously is being considered in the context of this consultation, is obviously the fact that it will give guidance, but for certain high-risk awards, maybe there is a bit more substance to what they're doing, and they're maybe in reviewing without giving a formal advice to the public authority. And that would give legal certainty to the parties that are receiving the award, the subsidy, but also ensure that we can show internationally that we are complying with that international obligation. In relation to who should have that role, there's been a candidate which has been discussed for a long time, and that is the CMA, the Competition and Market Authority, the Competition Authority in the UK. And at the moment, it seems that that should be the most likely candidate. As part of the TCA, there's agreement for a judicial role, but it is a very, very small role because, yes, you can challenge a subsidy, but first of all, it's subject to judicial review only. And secondly, you only have 1 month from the date of publication in the register to go to court to challenge it. So actually, one of the key points will be if the independent body will have a role, how does it fit with this 1 month deadline for judicial review? Because if a subsidy is looked at by the CMA, it might take them some more time than a month. So we'll see how the two are set up. And the court will have a couple of remedies. For example, it can quash or set aside the challenge subsidy. It can issue declaration that the subsidy is unlawful, and in very limited circumstances, it can award damages and recovery. So as you can see, again, the UK government is trying to create a regime which is not as sophisticated as the EU, and at the same trying to make it quite flexible. Again, the issues which should be the court, and again, one of the preferred candidates seems to be the Competition Appeal Tribunal, to which the decision of the CMA are appealed. The more so because the Competition Appeal Tribunal is a tribunal specialized in competition law, and they actually did consider state aid as one of their functions when obviously there were initial discussions after Brexit. So that brings me to the end of the presentation, which I hope has given you some ideas of what might happen. As I say, this is just a consultation, and obviously we're waiting to see the response from government. But a couple of points are, in my view, extremely important. Whatever regime we create, there has to be enough guidance and enough certainty for public authority to be comfortable that they're granting subsidies legally. At the same time, there has to be legal certainty for the parties that receive the subsidy. With all the disadvantages of the EU system, one thing is obviously an advantage in that regime. Once an aid has been notified, the participants, the recipient of the aid, know that the aid is legal. In this new regime, where there are principles, where there might be a challenge of a month, it's a bit more fluid, and legal certainty will be an important aspect, in my view, going forward for the government to consider. As I say, that brings me to the end of the presentation. I hope you found it useful. Feel free to contact me if you have any queries, and obviously we will follow this presentation with a new one once we have the proposals by the UK government. Thank you very much.